Well, I mean, there are, as through zoning, there is some bonding that can occur. I'm not familiar with too many communities that require it in the feedlot context. You see it pretty regularly with mining operations for reclamation, but it's a little difficult just to have a bond sitting out there just in case maybe something someday happens.
Well, and the question I got is because under the nuisance law, a landowner, if his property is damaged by the feedlot, they can't do anything, they can't sue him over it, in accordance with that nuisance law.
Well, yeah, I mean, you're right that the nuisance, there were some protections put into the nuisance law for existing farming operations, although that would protect a direct harm. I mean, you know, if there was a spill, you know, direct incursion on the property, that kind of thing. I mean, that's going to be direct harm. That's property damage. So you don't have to rely on nuisance for that. You direct harm by property. Nuisance is more of that, you know, harder to prove that it's you know, smells that are bothering me, those sorts of things. So that's why the different feedlot groups were able to get some protections for them to say that, you know, my farming operation does generate smells, but you should know that moving into a farming community that farms smell.
And then I had talked to the county highway department, they will not pave County Road 5 under any circumstances.
Okay, I'm not familiar with that issue. Is it, what are the hauling on it causing damage or what?
No, they just told me that they would not do it. Evidently it was up for a vote one time and then it got turned down. And evidently they don't want to spend the funds to pave it. And with all the truck traffic going in and out of the feedlot, with them moving, you know, more than 5 tons, which pretty hard to run a semi on. I can understand a farmer a week to 2 weeks out of the year, but when you're talking every week, it's gonna beat up that road, and there ain't gonna be nothing left.
Well, you know, that is a county issue if it's a county road, and so, you know, you certainly can talk to your commissioners, but, I mean, that's ultimately up to them. Some efforts have been made, and these are difficult, but there are towns that have attempted to enter into agreements for talking town roads with folks that are developing, whether it's animal feedlots or whatever, anything involving heavy hauling. If they think they're going to have a significant impact on the road, there are options to try to work out some sort of maintenance agreement where there's different ways of doing it, but some have done like an analysis of this is generally how much we spend on a road like this to maintain it in a year. And then if we end up incurring costs over and above that, we're going to assume it's from your hauling and you'll pay that. That's more of an agreement though, and some have agreed to something like that. Others, frankly, have been pretty blunt and said, no, it's your road, you fix it. You know, I'm a citizen and I get to drive on it and prove that I'm doing damage. And of course that's difficult unless there's something really obvious that gets stuck in your road or something like that.
That's not hard to prove on a semi. It's pretty easy. Going in and out, it wears out tracks. But nonetheless.
But I'm saying prove to a legal standard. That gets a little difficult sometimes.
And then I have one last question, and that's on the value of the properties. I have paperwork here from a case in Indiana showing between a 14 and 18.75 loss percentage-wise. Do we need to take and send you that?
Well, I'm getting some weird feedback there. Yeah, you know that when I was at the Township Association, I served on any number of committees with the PCA and Department of Ag and the state GIS on feedlots. And at one point way back, I think it was in the 90s, the legislature commissioned a study on property values. the University of a professor at the University of Minnesota did the study. And it was funny, I was in the hearing room when he produced his results. He actually, according to his study, property values around feedlots go up, not down. And of course, no one really believed that, and the study was pretty well disregarded from that point forward, even from pro-feedlot folks. So I think that's somewhat difficult to pin down. The explanation in that case was that some of these feedlots, some of the home sales that were occurring around them were probably from people working on some of the larger feedlots, so they were buying up some properties around there. And I don't know if that was ever proven, but that was one explanation of why it seemed to create this artificial increase in property values. So I think it's a factor you can consider that does have impacts both on potential impacts on property values as well as quality of life. And that's why you get into setback issues. And I don't know if you've studied the University of Minnesota now for years have had essentially a formula that they use, or a program that they've developed by having people go out into the field and smell at different distances from various kinds of feedlots. And so some communities have used that formula as a means of trying to determine setbacks. There's different factors that get into it: wind direction, topography, type of feedlot, if there's any sort of screening materials like trees planted, and essentially it's based on an annoyance factor, if you will. So essentially the small community or the community decides what kind of level of annoyance they're willing to accept, and then you go through this formula to determine what an appropriate setback would be. So that's been advocated by some animal folks, just as a way of saying there should be something that's more tailored to the situation rather than a straight quarter mile, half mile, something like that setback.
Well, I've been getting a lot of my information from Todd County, one of the commissioners there I went to school with. And so I got a little bit of insight on what they're going through. And I'm got my camper down there. I drove up from there today just for this meeting, but I plan on going out to Gurley's, and then I got some information of another place that is being hush-hush about it. But
Okay.
Okay, next questions. We take some off the sheets here, some of the ones that came in from prior to the meeting. The Norman County Commission has stated that if townships establish their own ordinances that are stricter than similar county ordinances, it is totally up to the townships to maintain, regulate, and enforce those ordinances. If that level of relationship, is that level of relationship between county and township common across Minnesota?
Yeah, that's the way, put it bluntly, that's the way it works. If you adopt an ordinance, it's yours. You're responsible for administering and enforcing it. The county has absolutely no obligation to enforce it. Now, sometimes counties will work with you and not enforce it, but will tell someone that, that comes in their office for a zoning permit, they're seeking a CUP for a new feedlot. They'll say, oh, you're in XYZ township. We know that they have a cap of X number of animal units in that town, so you may want to go talk to the town because what you're proposing exceeds that. Now, technically speaking, the county is absolutely within its rights to process that application and approve it, even though it may exceed the limit that the town has enacted. And then it's up to the township to say, yeah, you may have gotten the county's permit, but we don't allow that of that size. And so you're going to have to come through our process, and we're only going to permit you up to, whatever our cap is.
How is the zoning committee set up at the township level? What are the basic, do you know the basic steps and costs and number of people required to do that?
Yeah, basically in order to set up a planning commission, the town board adopts an ordinance. It says, basically we hereby establish a planning commission. It sets out some of the criteria of it, talking about powers and that, but as far as number of members, I just had a small town of mine that we established a planning commission, I don't know, 4 or 5 years ago. And I think at the time they said, well, we want 5 members. So we established it with 5 members, and now they just came back, they're gonna amend it to reduce it because they can't find 5 people willing to serve. So, I mean, that is a challenge sometimes. Often it's easier when a new issue is coming up or it's hot or you're just getting involved in it. Kind of the newness wears off and trying to find people that are willing to go along with it in the long haul, sometimes it's difficult. But one thing that some boards, depending on how active you want to get involved in zoning, if at all, if you have a real active, if you're intending to really jump in and do zoning, you know, where you're going to be processing permit applications with CUPs and that sort of thing, frankly, you want a separate group of planning commission members just so they help bear some of the burden. But how, on the other hand, if you're doing a relatively minor set of regulations where you're not processing and a lot of CUPs, you're not conducting public hearings on those, then the town board can appoint itself as the planning commission. So you don't necessarily have to create a separate group of people. You can just say that we, the town board, are the planning commission. You still have to adopt the ordinance, but you can make yourselves the planning commission.
Follow up on that topic? There is concern that feedlots will spread in surrounding townships that do not have more restrictive feedlot ordinances. Have any townships in Minnesota banded together and approached their county about amending zoning ordinances or adopting new ones?
Oh, I'm sure they have. I mean, for the 23 years I've been working with towns, I recommended that as a starting point. Because adopting a zoning ordinance is frankly a big deal. Even if it's a relatively minor ordinance, it's still a big deal for the reason we talked about earlier. That's all on you to enforce it. And enforcing a zoning ordinance can quickly run up to $20,000, $30,000 pretty quickly to enforce it. So it is a big deal. Not that you're spending that kind of money every year or anything like that, but if you can find yourself in an enforcement situation pretty quickly, and again, it just costs a lot of money to go to court and fight these things, which can take a year or two minimum to deal with, if not longer. But as far as banding together, my point in all that is because of all those potential costs, headaches, etc. I always say your first step is when you look at the county's ordinance, and if you think it's not restrictive or effective enough for some reason, then yes, get together and say, hey, county, we would like you to do this. Amend this ordinance to put a cap, decrease the cap, put this element into this that we think is needed in order to protect us, the taxpayer and citizens of this county. And then I would say that's his first step. And if working through that process doesn't work, you know, you're not successful in getting whatever additional protections, then as a town or a group of towns, then you can look, okay, well, that didn't work. Now it's up to us. Are we going to step up and do it ourselves? And be willing to take on all of the headaches and costs that I just mentioned.
Regarding jurisdictional matters between adjoining townships, for example, if a residence is within 200 yards of its township border, its township has a 1 mile setback between residences and feedlots. Its neighboring township has no setback ordinance, or one equivalent to the county's 1/4 mile setback. Can a feedlot be constructed within 1/4 mile of the residence in the adjacent township? Again, you've got a house that's within 200 yards of the township border. It's in a township with a 1 mile setback. The neighboring township has a 1/4 mile setback. Can, in the neighboring township, a feedlot be built within a 1/4 mile of that neighboring township's residence?
I think most interpret that as 1 mile setback from, you know, whatever it is. If it's from a residential structure, it's a residential structure. It doesn't matter if it's on this side of the line or that side of the line. It's still a setback. So I think you'd be legitimate in saying that you have to apply our 1 mile setback both within and outside of our boundaries.
Follow up?
I have a question. If a few townships wanted to band together, what kind of an organization would they need to create to be an entity of themselves? You know, we have, I guess, to work together like that.
Yeah. Well, that's a good question, because that is one way to help reduce the work and costs and headaches of getting involved in zoning. There's different ways you can do it. There's sort of an informal way you can work together, and that's by saying, look, let's all work together and talk about a zoning ordinance, kind of work together with someone like me to have me draft the planning commission ordinance, draft a zoning ordinance that then each of you would have access to and then can tweak for your particular town. Because frankly, that's cheap rather than working with a bunch of individual towns, because having to explain everything 2, 3, 4 different times versus just to a group like this or to a group of town officers and just produce something for you collectively. So and so you're not really working together in a legal sense. It's just more we're trying to be cooperative in this, but we're all ultimately going to end up doing our own thing. So that's one model. The other model is to do it formally and legally work together through a joint powers agreement. And I represent a joint powers planning group up in Bemidji that for years have planned together where they've created a joint planning board that is the governing body, which is the deciding authority for zoning. And so that governing body has its own planning commission that's independent of any of the communities. Now, of course, they're made up, the joint planning board is made up of appointed members of, in this case, it would be the towns serving. So say you get 4 towns, you'd have 1 or 2 members appointed from each of the towns to sit on this board, and then you'd have a planning commission that's appointed. And so what ends up happening is that if I was in your town and I wanted to apply for a permit in any 4 of my hypothetical towns, you would go to that board, to that body, and make application and process it through them. It never goes to the individual townships. It's all just through that joint board. So now, of course, doing that is a little bit more involved because you have to create a joint planning or a joint powers agreement. You'd have to separately purchase insurance for that body because it's technically an independent body. So they'd have to have their own insurance, their own checking account. You know, you'd really be setting up this subsidiary entity that is on its own.
Any major costs in that process, the formal one, as far as what you got a rough guess?
What the cost would be? A lot of that, no, I mean, first of all, I haven't seen many towns do that, frankly, at least formally like that. I've seen it more in the informal, let's just work together and kind of share documents, that sort of thing. But the JPA, the Joint Powers Agreement, would need to be drafted. That's what each of the towns would adopt to formally create this group. That would probably, well, it depends on how, frankly, if you all agree, it's pretty easy. If there's a lot of disagreement and changes, it gets a little bit more expensive because it just takes longer. This is just off the top of my head, but I would think 10 to 20 hours to put something like that together. And then there's bylaws that you would have to draft for the group, so they would have some set of documents to conduct themselves by. That's probably another few hours. And then what else? You'd have to create the planning commission, but that's wouldn't be all that difficult. Another hour there. So cost-wise, you're probably $5,000 to $8,000, something like that, roughly. It's always hard to guess on these things because each one of the things are different, but I'd say somewhere in that range would be my guess. Oh, I should always, I've learned the hard way that I always need to throw in a caveat on that. Those hours, those guesstimate on hours is focused on working on the documents. You know, that doesn't include spending 3 hours on the phone answering questions, attending meetings, any of that sort of stuff. That's just tabletop, sitting down and drafting documents.
Okay, locally there is concern that the county feedlot ordinances provide greater setbacks from citizens within municipal borders than from rural citizens. For example, fewer than 300 animal units equal a half-mile setback from the municipal borders in Norman County versus a quarter-mile setback from private residences in Norman County. Are multiple urban residences generally considered worthy of greater setbacks than single rural residences?
I mean, there's no general rule on that. I mean, each community sets up its setbacks and what those criteria are. And so when I answered that question earlier, that personally I would treat the setback as being from residents even outside of the boundaries of the town. That's the way you can do it. You don't go to the county and say, well, Troy said you have to do it this way. It's up to them to interpret and apply their setback. What I was saying is that if you have a setback, I think you can legitimately apply it that way. So the county apparently has set up different criteria based on, well, jurisdictional boundaries, which I can tell you is not all that unusual. It's, in my experience, you know, there's a recognition that we don't necessarily want intensive agricultural uses next to developing residential or municipal areas, just because, you know, the presumption is that's where more concentrated housing is going to be, more people are going to be living in a smaller area, and we should be having, again, intensive agricultural uses in those areas. So it's not that unusual to have either zoning districts being different around city boundaries that preclude some of those issues, or perhaps different setbacks. So, I mean, yeah, frankly, that's what I'm sure someone on the other side of the table would tell you is, well, if you live in the country, you're living next to farms and smells. If you're living in the city, there's a different sort of expectation of, I'm not living out in the country, I shouldn't be confronted with those sorts of impacts.
We've seen ordinances in Minnesota, for example, that provide greater setbacks to people involved in the hospitality industry within an agricultural area. Is it common for specific types of businesses in rural areas to be provided additional setbacks beyond private residences?
Could you give me a quick example of that?
Well, for example, the township that I was looking at was protecting, obviously, its bed and breakfast and resort industries, providing them a larger setback than private residences in the agricultural district.
I see. Yeah, you know, I don't think I've seen that all that often in feedlot regulations. You certainly see that with some more potentially troublesome uses, I guess I'll say, liquor, adult uses, that sort of thing, and setbacks from schools and churches and that sort of thing. So it certainly is something you see in zoning ordinances. I just don't typically see it with feedlots, other than maybe the municipal boundary issue and some of that.
The Minnesota statute that states that setbacks between residences and feedlots are reciprocal.
Yep.
Is it possible for a township to pass an ordinance that negates that reciprocity?
No. No, your authority is limited by, you know, you only have the authority the legislature gave you, and it's subject to whatever restrictions or limits they place on that authority. The reciprocal setback, I was there when they put that in. Senator Dill, I think, was the author of that. He was making it clear that, look, if you're saying a new feedlot has to be so far from an existing home, then it's only fair that a new home has to be set back the same distance from an existing feedlot to avoid the nuisance issue that was talked about earlier.
Have any townships or counties passed ordinances allowing legacy landowners to construct feedlot operations on their properties that are non-compliant with ordinances restricting feedlot construction elsewhere in the township or county?
If there are, I haven't seen them. I can't say, I'm around the state, but I can't say I've seen every ordinance out there. And part of the problem is you have to be, from a drafting perspective, you have to be consistent. And so if you're making a distinction between, this rule applies to you and this rule applies to you, and it's a different rule, you have to be able to legitimately distinguish why those regulations are different. There has to be a reasonable basis for imposing a greater setback, for instance, on you than I'm imposing on someone else, or greater restrictions. And I'm not saying that there may not be, but just the longevity or being a legacy doesn't necessarily create, it's not a protected category or, classification or anything. So I frankly, off the top of my head, I haven't given a great deal of thought, but off the top of my head, I would be a little concerned about trying to punch holes in a regulation just because someone is deemed a legacy farm.
There were questions regarding roads. We've covered some of them already. One specific question was mailed in. Is it legal for trucks from feedlot operations to come off 10-ton roads onto lesser rated roads?
No.
Well, township roads generally do not have, there isn't a default limit on town roads. Just during the spring rate restrictions, then the restriction goes on, but other than that, there is no automatic. So, so I somewhat challenge the question, is it truly a lower rated road? It may not be in good shape, it may not truly be able to handle that kind of weight, but unless the township has actually gone through the process to designate a weight restriction on that particular road, it's really not rated at anything outside of the spring weight limits.
I beg to differ with that. I talked to DOT and the county highway department. All
Yep.
gravel roads are classified 5 ton. That's it.
They're actually not. I would challenge that person to provide you the statute that says that.
Okay.
Okay, moving on, the advisory committees have gathered considerable evidence showing negative health effects on residents, including, but not limited to, asthma, MRSA, and hydrogen sulfide exposure. Question mailed in, is there a value in dollars and cents that can be put on a human life and on human health when considering ordinances having an economic impact on the community? Are you aware of, in other words, are you aware of townships or counties measuring economically the value of the lives in their communities versus the economic potential positives of an incoming operation? Are there standards for that?
Not that I'm aware of. I haven't seen any that have actually tried to somehow involve that in the zoning ordinance and any sort of regulatory scheme. That generic environmental impact statement that was created some years ago, one of the components of that study was a health impact study. So if you folks haven't seen that, you may want to take a look at it. You can search it on the internet. It was done by the state. I was one of the members that served on it. We sat for, 3 years and hired consultants to put it together. So you may want to look at there was an attempt to recognize the fact that, yes, there are potential health components of animal agriculture, and so that was an attempt to get at that. You can find all that, like I said, each of the component elements of the study are online.
Do any townships or counties in Minnesota have ordinances against composting carcasses during winter months?
I remember that issue being talked about in some communities. I can't recall a specific ordinance. There may be, although they have, I think the argument is that the Department of Animal Health deals with some of that. But yeah, off the top of my head, I know that's been talked about, some concerns regarding what's done with carcasses. But off the top of my head, I can't think of any ordinances that I've seen recently that have dealt with it.
Do any Minnesota townships or counties have ordinances banning aerial dispersal of manure?
That one I don't think I've ever seen.
Okay.
Can't say that there aren't any out there, but you know, some of these questions you may be wanting to ask, you may want to ask it in a way that, do I know of it and do I think it's legal to do that? Yeah, to be within your authority, because I mean, that's the other aspect of this is, you know, your authority, as we talked earlier, has limits. And so you do have to be somewhat careful, and in the feedlot, I'll just give you a quick example. This whole battle started in the early 90s when more concentrated animal feeding operations started in the state, particularly hog feedlots. And townships jumped on and started to enact ordinances. Some of the first ones, the Hawk Creek Ordinance was adopted, using the town's general police powers to try to regulate it. That went to court. That was defeated. They had things in there like limiting the spreading of manure. I think it even got into some of the chemical components, or so much nitrogen or something like that. And basically what the court said is that, township, you have exceeded your authority. You have essentially trampled on the ground that's reserved for this pollution control agency. And so we're going to find, the technical term is preemption. We're going to find that ordinance is preempted by the authority given to the state, and therefore this ordinance is not valid. So you do have to be careful about trying to regulate based on any sort of pollution standard. Because the county, actually, the way the law is set up with feedlots, counties do have some of that authority, whereas townships do not. So you have to be careful about, you know, what's the basis for the regulation. So the way I used to say it on the phone when at the Township Association, when towns would call me, I'd say, if you're trying to get into so many parts per whatever, or certain nitrogen standards or anything like that, you're probably going to get blown out of the water as being having exceeded your authority. So the aerial spreading, those sorts of things, I think you probably could get at that from a nuisance standard, because I've been around some of those, and they create an interesting smell that perhaps is not, that perhaps is more intense than just a traditional land application.
Okay, zoning issues have been seen to cause social and political rifts in some townships and counties, sometimes resulting in litigation. Have townships in Minnesota been sued for passing ordinances regulating feedlots or other operations within their jurisdictions?
Yes.
Have the suits been for anything other than procedural errors?